You know, what do we want to call it? The Alex Murdaugh case is, and I typically don't want to call cases by the name of the perpetrator. I usually want to call them by the name of the victims in this. So I guess the Maggie and Paul Murdaugh case. But this is one that I was YouTubing at the time it was happening, but I wasn't live streaming. I wasn't doing the daily news stuff. I was doing deep dives into cases at the time. So this might be the first time we've talked about it here on my channel. But I've followed it with extreme interest because of the nature of, I guess, the circumstances of everything that happened down there. Small town, kind of like multi-generational power dynamic. It just, and then like a family that seemed to have been able to get away with anything. And then I guess the second generation patriarch going off the deep end, and in order to cover up his other crimes, completely offs his wife and son. I'm not even going to say allegedly, okay? He was convicted of it. But that conviction was overturned by the South Carolina State Supreme Court, and I kind of think appropriately so. Because you guys know, I think every defendant deserves a fair trial with good representation. And when that doesn't happen, it threatens that protection for all of us. And the Supreme Court of the state of South Carolina, I shouldn't say agrees with me. I should say I agree with the state Supreme Court there in South Carolina. We have their decision, their opinion that remanded this back and ordered a new trial. We're gonna get into that opinion. What else do we have? We've got so much to go over today. We've got that. We've got headlines in the Nancy Guthrie case, Anna Kepner, Judge Kevin Mullins, the Lake and Snelling case. We've got some good news, and of course, we've got 3 questions. So, as they say, we got 10 gallons of content to put into a 5-gallon show. Feel like this one might be a long and in-depth one. Hope you will stay with me. This video contains mature themes and discussions intended only for adult audiences. Viewer discretion is advised. Hello there, my friend. Welcome back to another true crime conversation with me, Gavin Fish. I have been battling like gremlins all day today. In fact, I'm wearing this sport jacket because I've been so cold, but it looks like it is my father's sport jacket. It's the smallest one I own, and it's way too big for me. Just I'm drowning in it. It might as well be a double-breasted coat. So there's that. Plus, we weren't live yesterday because we had gremlins that I was blaming on like living in a small town and bad weather and everything. But it turns out that we had just a bad network set up, and whoever set up that network, that guy's name was Gavin Fish, did a terrible job. But today I've spent all day fixing that. So I'm hoping that we are in the clear there, that this will reach you wherever it is that you are. Tell me, you put GF in your comment and tell me where you're tuning in from. I just love to read your comments and know where you're watching. In addition to all that, I've told the story a couple times on the channel here where a scoutmaster of mine, I told him at the tender age of 12 or 13 that I just didn't think that I ever had it in me to kill a person. And as a Vietnam veteran, he looked at me straight in the eyes and said, "Yeah, you do." And that has been a lesson that I have taken with. It scared me to death. It's a lesson that I've taken with me my whole life. Well, I found out yesterday that he died the day before yesterday pretty sad about it. At the age of 80, which, you know, seems it's too young. And then my beloved Uncle Phil, my mom's oldest brother or only brother, passed away a couple days ago as well. So just a lot going on over here in my world. In the case of Uncle Phil, I'm sad for my aunt, for my cousins, but after a long illness, I'm happy for him that he doesn't have to deal with that anymore. So mixed feelings, of course, mixed feelings. Of course, my mom now is the last surviving member of her immediate family. Her parents are gone. Her little sister is gone. Her older brother is gone. So I'm thinking of my mom, thinking of my aunt, all my cousins, my aunt and uncle's grandchildren, and so forth. It's just a lot going on. But that's the way it is in every life, right? In every life. There's always life that goes on. And, you know, this is, and I'm sorry to just go on and on and on, but if you live in my area and you read the reports that I put out on the EYT media network on Explore Venango, Explore Clarion, Explore Jefferson, right now I am working on a long series about the battles of drug addiction, people who live with drug addiction, people who live beside people that live with drug addiction, those that respond to it privately, publicly, through law enforcement, through the courts. I've had some of the most amazing conversations, had some of the most just amazing. Today I talked to a 30-year EMS veteran that told me some of the most surprising things that I can't wait to include in my report. So for those of you that are local, I know that there are a few of you that watch that are local. Keep your eye open for those reports. And then one other thing I wanted to mention before we really get into it, something that I'm so excited about. I know I'm like on a roller coaster of emotions here, and things that are happening in life. Look what I'm wearing. You see what I'm wearing right there? That there's a reflection. You guys couldn't see it. This, well, it's got a white face. This is the first really nice watch I ever got. Fun fact about me, my modest and small collection of watches are all either gifts or bonuses that I've gotten over the years. But this one is the first one I ever got. It is a chronograph. And do you guys know what is happening right now? I have partnered with Fan of Them to give away this Omega Speedmaster. Now, I'm not wearing a Speedmaster right now. I wish I was wearing a Speedmaster right now. I'm wearing a Daytona. But I love watches. I just love the craftsmanship of them. I love that they are something that you can pass on to future generations. And I've teamed up with fanofthem.com, which is a veteran-owned small business, to give away this Omega Speedmaster. It's about a $4,900, $5,000 watch. Pretty awesome. And to enter, all you need to do is go to fanofthem.com/Gavin Fish. You buy some cool merch or a digital download, one of their collectibles, and you get a chance to win this Speedmaster. And by doing it, you also support the show. I'm always blown away by the amount of support that I get from you guys, from the comments and the likes and the people that subscribe, my patrons, my members. I am so grateful that you guys do this. And just I hope that one of you really enjoys this Speedmaster. Definitely go to the link in the description or to fanofthem.com/Gavin Fish. Grab some of that limited edition merch or a digital download. Get your automatic entry to win this amazing Speedmaster. Thanks again for your support and good luck. Can't wait to see the winner on that. Okay. Have we already done the intro? I've been talking for almost 10 minutes. Yeah, we did the intro. What are we doing? Okay. We are jumping into this case. We're jumping into this case. This, my friends, This is Alex Murdaugh. Okay. He's an attorney. He is a convicted murderer whose conviction was overturned by the South Carolina State Supreme Court. Why was it overturned? Well, first of all, what was he convicted of? Well, he was convicted of murdering his wife, Maggie, and their son, Paul. And, this was the Murdaughs were a powerful kind of dynasty down in South Carolina. He was a well-known attorney. He had ties to local prosecutors. He knew local law enforcement. And, they were already under scrutiny because in 2019, Paul, that young man right there, do I have a picture of just Paul? I guess I don't. Anyway, Paul, the young man in that picture right there, was involved in a boat crash that killed a young woman named Mallory Beach. So there was already some what do we want to call it? Some scrutiny, right? Because not only did Mallory lose her life, but it appeared that Paul was protected by his extremely powerful family. And in my opinion, he should have been prosecuted. If you've looked at all this, if you've watched the documentaries on this case, if you've read about, oh my goodness, it is. So Alex and Maggie protected their son, I think, from prosecution. Okay. But in the meantime, Alex was committing all sorts of financial crimes. Now that part, I don't think that part has been overturned. But, the prosecution's theory is that Alex killed Paul and Maggie because he was trying to he was trying to distract. Well, I don't know. He was trying to distract from his financial crimes and his personal scandals. He had millions of dollars that he had stolen from clients and associates. And of course, the prosecution just had tons of evidence on this, including video recorded by Paul minutes before the murders, which prosecutors said placed Alex at the scene of the murder, which was their dog kennels, despite the fact that he had denied it. The prosecutors had evidence that Alex had changed his story over and over again about where he was that night. There was testimony about his financial crimes, his misconduct, his opioid addiction. Speaking of addictions, tons of like digital and forensic evidence. The defense was like, you know what? They did everything that defense did, right? The investigation was flawed. You focused on our client from the beginning. You didn't focus on anybody else who could have committed these crimes. There was no direct physical evidence. You were ignoring other suspects. My client lied about some things because of his paranoia and addiction, not because he was the killer. But in 2023, the trial took place. He testified in his own defense, which hardly ever happens. I feel like I'm screaming. Let me pull. Sorry about that, guys. If I'm blowing out your eardrums. He admitted that he lied to investigators about being at the kennels, but, said it wasn't me. But anyway, March of 2023, he is convicted of both murders, and he receives 2 consecutive life sentences. Done, right? All is groovy at this point. Except there's this woman right here. This woman's name is Rebecca Hill. Okay. Rebecca Hill what was she? She was the court court clerk. Is that what she was? I think that's right. I didn't jot this down. Anyway, uh, the defense, after the convictions, accused Rebecca Hill here of improperly influencing jurors by making comments about their client's credibility, his body language. They said she was encouraging jurors to not be fooled by his testimony. They said she was discussing evidence and impressions outside normal courtroom procedures. She was pushing jurors toward a quick guilty verdict. And the defense said, she was too personally invested in the case and its outcome. And you know what? This is the kind of crap that you see in small towns where a guy that has too much power, and I'm not saying appears to have too much power, he has too much power, is starting to get his comeuppance, right? I mean, where else are we seeing this? We are seeing this in the case of Judge Kevin Mullins down in Kentucky, right in Letcher County, Kentucky. Kevin Mullins was killed by Mickey Steins, the sheriff in the town, right? And so we're going to see the same kinds of things in this one. Did Judge Mullins deserve to be killed by Mickey Steins? That's the kind of stuff that Rebecca Hill was feeling, apparently, right? All the evidence points me in that direction anyway. And so, afterwards, Rebecca Hill wrote a book. She wrote a book about the case called Behind the Doors of Justice, and that became a major issue because the defense argued she had a financial motive now to help produce a dramatic guilty verdict. And some jurors later testified about comments that Hill made to them, allegedly, during their deliberations, and questions emerged about whether she blurred the lines of ethics, right, while the trial was ongoing. And then separately, investigations started and accused Hill of sharing sealed evidence improperly, misusing her office, making false statements under oath, and using her position for personal gain, tied to media attention, tied to the book. She eventually resigned from office, and then she was later charged with those misconduct-related crimes, ultimately pleaded guilty to several offenses tied to her handling of the case and the courtroom material. So that is our background. That is what got us here. Okay? And of course, not bearing the lead, South Carolina Supreme Court was like, we can't be doing this. We can't be doing this. Now, before we get into that, let's see what you guys are saying over in the live chat already. Looks like we got several people. Christine Meadows is saying, I'm looking dapper today. Feel like I'm wearing my dad's suit. This was a sport coat that I bought that was too small for me. And now I was wearing a 52 long at my heaviest. This is a 44 long, and like the shoulders are about 2 inches too big on each side. It's really funny. But thank you. Thank you very much. Let's see. New Hampshire is here tonight. Let's see. Barb Olson says you'll have to take up tailoring as a side hustle. You know what, Barb? This is a bit of a tangent, but I just had measurements taken and have ordered my first made-to-measure dress shirt. It's my first time purchasing. It's not bespoke. It's not, it's not. I didn't have to spend a lot of money on this, but it's made to measure, and I'm gonna see how it goes. See if I like it, and if I do, I'm probably going to start. I think I will probably buy a made-to-measure suit. Yeah, Just Ducky, Gavin all fancy with his blazer. The UK is in the house. York, PA is in the house. Calgary is here. Austin, Texas is here. I do need a new sport coat that fits me. We're going to see how this shirt goes. And then we will. I'm so cold. That's the other thing about losing weight, guys. Like I'm just always cold. Always cold. South Lake Tahoe here, Northern Kentucky here, suburb of the Windy City is here, Flood City, PA. Savannah, Georgia is in the house. England is here. Glad you are here. Erie, PA. Oh dear, Josh Ritter's mom passed away. I didn't see that. I'm very sorry to hear that. I'll have to reach out to Josh. Georgia is here. Thank you guys for the condolences. Appreciate that. Those were two really, really good men who made my childhood just a little bit happier. Both of them. Just, I never am terribly sad when somebody old who has lived a full and rich life passes away. Of course, I will miss them. But both of those guys, both of them, in different ways, made Uncle Phil and Bruce made my life so much happier as a child. And I already had a really happy childhood. Both of them. Amazing. And thank you guys. I appreciate that. Marie Jubenville, thank you Meadowbrook, thank you very much. Meadowbrook, Alabama is here. Sharky Sharona, thank you for covering stories of addiction. I'm learning so much in that series. Oh, well, thank you. I appreciate the hug. I'm Goddess. I appreciate that. Let's see. Mary says, glad you're reviewing Maggie and Paul's case. I've always believed Alex was guilty. It's a shame Becky Hill interviewed. Yeah. This is the crappy thing. It's because I believe that Alex Murdaugh did the murders. I feel like there's so much evidence, and we now have to go through a second round. There will be tons of time and treasure invested in it, but it is the right thing to do. And we are going to get into it here. Let's see, a couple other things. Let me see if anybody else is. Yeah, she was the county clerk of the court. That's correct. She was the clerk of court for Colleton County. Court clerk. Yes, that's what she was. Thank you very much. Beantown in the house, Lansing, Michigan. Seawater says, get my shirts handmade to measure by iTailor. They are perfect. Well, Sea Waters, that is where I decided to try mine at iTailor. That's what I'm doing. I'm glad to hear that. I chose the 80/20 by 80/20 cotton. Feel like it's going to be a fabric. I like natural fabrics. So yeah, I'm glad to hear that. Thank you. Robin says, my dad always had tailor suits and they always fell so nicely on the shoulders, cuffs, and pant cuff. You look fabulous, darling. My dad is the same way. Always tailored suits, always looked great. So yeah, and I'm trying to up the old game. Myrtle Beach, South Carolina, Baby Shark, welcome. Glad you're here. I'm trying to up my game. When I was walking around at nearly 3 bills, I really was just trying to cover my body so nobody would notice how ginormously fat I was. And of course, everybody noticed how ginormously fat I was. So now that I'm down below 2 bills and continuing to drop, I'm trying to get the right drape, trying to look better, because I feel better. I want to look better. You look marvelous. Feel marvelous. Yes, indeed. So, okay. Guys, will you come with me, please, over to this here Acrobat file? This is the Supreme Court file. It's a 29-page filing. These actually go pretty darn quickly. But I think it's important we go through the whole thing. It will give us background. It'll give us the opinion. This is the state of South Carolina in the Supreme Court. The state v. Richard Alexander Murdaugh. Oh, dang it. Okay. The only thing I'm sympathetic to in Alex Murdaugh's life is that his family named him one thing and called him another. I also am a middle namer. And my parents said that John Gavin Fish sounds way more musical than Gavin John Fish. And that's why I was named John, but called Gavin. Poor poor, not so poor, Alex Murdaugh, appeal from Colleton County. Here is the opinion filed yesterday, May 13th, reversed and remanded. And then it just lists the attorneys. Okay. Per curiam. For 6 weeks in early 2023, the eyes of the nation focused. This is the court writing this, by the way. The eyes of the nation focused on Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife, Maggie, and son, Paul. Interesting that they use the word notorious. Holy cow. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. All right, so they're like, the defense did a good job, the prosecution did a good job, the court did a good job. However, their efforts were in vain because Colleton County Clerk of Court Rebecca Hill placed her fingers on the scale of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury toward a biased verdict. Although we are aware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for a new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance on this thorny issue to the trial court on remand. So they've got some instructions, all right? So they're like, we know that you're going to spend a lot of money on this. It's going to be a lengthy trial, but we have to do it because everybody is entitled to a fair trial by in front of an impartial jury. Otherwise, it all falls apart, right? And we want this. I mean, I don't want, what I don't want is for somebody like this to nullify the impartiality of the jury. Got to keep the jury clean. And I know that some people might think, well, that's rich, Gavin. You taint the jury pool by talking about cases like this all the time. No, that is what voir dire is for. That is what voir dire is for. They are to find an impartial jury. And now they have to do it again in a county where, I mean, the eyes of the world were on the county. Everybody has heard about this, but there's a voir dire process and practice that will find an impartial jury. Okay. Number one, in terms of guidance, here we go. Factual and procedural background. On March 2nd, 2023, Murdaugh was convicted of the murders of his wife, Margaret Murdaugh, and his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sentenced him to life in prison. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance to allow him to file a motion for a new trial. The Court of Appeals granted this motion. On October 27, 2023, Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising it not to believe Murdaugh's testimony and other defense evidence, 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the court remove a juror she believed to favor the defense. He attached affidavits from several jurors to support his motion. Chief Justice Beatty appointed former Chief Justice Toll, post-trial court, to preside over this motion, as the trial court judge had recused himself. The post-trial court conducted the hearing of this motion on January 26th and 29th of 2024. During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement about the verdict at the time, 2, whether the verdict was, quote, based entirely on testimony, evidence, and law presented, close quote, in the case, 3, whether they heard Hill make any comment about the case before the verdict, and 4, whether their verdict was influenced in any way by any communications by Hill. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill say before Murdaugh's testimony, quote, looks like the defendant is going to testify, this is an important day, close quote, or, quote, this is an epic day, close quote, and that it was rare for a defendant to testify. Juror X said these statements did not impact the verdict. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said, quote, to watch his actions, close quote, and, quote, to watch him closely, close quote. Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, quote, to me, it felt like she made it seem like he was already guilty, close quote. Remember, this is just me, taking a break for those of you listening, not watching. Remember that when you are sitting in a jury, especially on a homicide, and this is a double homicide, and I happen to be, I know I bring it up way too often, a former juror on a double homicide case, there is tons of weight, man. There's tons of weight on you because you're like, dude, I'm not a lawyer. I don't know the law. The judge has read to me what I'm supposed to consider for the law, but they won't let me take those instructions to read them. If I have questions, I have to come back, and then the judge just reads them again, and you're confused. You're not a lawyer. You're confused. And then you're in a room with other people that range on the spectrum from brilliant to idiotic, and you can't believe that these are the 12 people that were chosen. And they thought the same thing about me, right? These are the 12 people that are chosen to do this. There's just so much pressure. And I can see how comments like this, though they may feel banal, I can see how they can add pressure to a juror. Okay. Continuing the document. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror Z's affidavit gave a more detailed recitation of Hill's comments. And this is a quote from the affidavit. Toward the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled, close quote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury, quote, to watch him closely, close quote, immediately before he testified, including to, quote, look at his actions, close quote, and, quote, look at his movements, close quote, which I understood to mean he was guilty. Should I stop with the open quote, close quote? I probably should. Okay. Getting back to the court's writing. This is not in the affidavit. Juror Z testified that when the jury began deliberations, Hill told the jury this shouldn't take long. In addition to referencing Hill's statements, Juror Z averred in her affidavit, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. You shouldn't do that. You should vote your conscience as a juror. Having said that, I think I put a lot of pressure on other jurors that I served with because I felt so. I mean, that's part of the deliberation. But if you're only feeling pressure as a juror, that's not a reason to change your mind. If you are convinced by another juror of something, then that's a good reason. Okay, after reviewing the affidavit, the post-trial court questioned Juror Z. This is from the post-court trial. I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered the question, yes. In light of what you said in the affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors, is that answer that I just read a more accurate statement of how you felt? Juror Z answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she answered yes. Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room. And once deliberations began, she felt additional pressure from other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Juror P testified that on the day Murdaugh was to take the stand, Hill made a comment to watch his body language. He denied Hill's comments influenced him in any way. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Following the jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day Murdaugh testified, and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. Oh, so she's like, I did not tell them that, but they may have heard it. She also stated that she gave jurors a, quote, little talk, instructing them to pay attention, and that the day was a big day. She denied attempting to influence the jury. That is completely out of bounds, completely improper. Makes me wonder, is clerk of court is I think clerk of court is an elected position. Is that correct? I want to look that up. Yeah. Is it, let's see, in South Carolina? Yes, in all 46 counties of South Carolina. There's got to be a training, though. Come on. I mean, come on. Okay. Continuing. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, I don't mind her writing that, by the way. I honestly don't mind her writing that, except she was influencing the jury. That I mind, okay? Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her, but she acknowledged as true a passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. The post-trial court also questioned Hill about the favors she granted the media. Hill denied allowing the press to view exhibits, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Although the post-trial court limited discussion of Juror 785, whom the trial court dismissed on the day deliberations began for allegedly discussing the case with third parties, it allowed Murdaugh to question Hill about bringing into the trial court's attention social media posts that Hill mistakenly believed were from Juror 785's ex-husband. It's a small place, right? So they're putting two and two together. Hill claimed the jury was very talkative while Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging the juror in discussion of these matters. In contrast to Hill's testimony, Juror 785, take two, Javi. Juror 785 averred at the hearing before the trial court and in an affidavit Murdaugh attached to his motion for a new trial that Hill interrogated her about the social media posts and whether she had been in contact with her ex-husband. Again, completely out of bounds. In the affidavit, Juror 785 related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers questioned the ex-husband about the posts, offered to reinstate restraining orders Juror 785 had against him, and speculated that the Murdaughs probably got to the ex-husband when he called Juror 785 on the morning of the verdict. Juror 785 asserted Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. She also stated that before Murdaugh testified, Hill told the jurors not to be fooled by the evidence Murdaugh's attorneys presented. Wow. Guys, in my experience just reporting from court, like the entire staff of the court is just so careful. Not only not to influence the jury, but not to appear to even come close to anything resembling jury tampering or even talking to the jury. Like the only people that should be talking, the clerk of court should not be talking to the jury. There are tip staff that are specifically that, right? They're like the jury staff that usher them in and out, make sure that they are in the jury room, make sure that they get their lunches and all that stuff. Clerk of courts might be like a supervisor of that tip staff, but why I've never seen anything like this. And in the 3 counties where I cover this stuff, I know the clerks of court. They're always so professional. I, I and I live in a small place where this kind of stuff could happen, right? Well, it could happen anywhere, but where I feel like it's more likely. Oh my goodness. Let's pause here and see what you guys are saying over in the live chat. First of all, Robin, thank you very much for the super sticker. I deeply appreciate you. Let's see. Let's see. Da, 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 da. Sarah Autumn 27 says the important question is how many other trials did she do this to? I feel bad for that county and the job they had to have ahead of them. That is an important question. How many times did she do that? It sounds like when I'm at work. Minneapolis checking in. Yeah, being in a room with people who you can't believe were chosen, ranging from brilliant to idiotic. Yeah, that is honestly. I when I was in that jury deliberation room, there was one person that always comes to my mind. It was really funny because I was maybe 25, 26 years old. Like I was a young man when this happened, and I really wanted to be the foreperson and couldn't believe it that nobody wanted me to be the foreperson. Well, of course they didn't. I was a kid, right? Who wants a kid in charge? So I remember the foreperson, and I remember I remember his face, I remember his voice, and I remember thinking, actually, this guy. And as a younger guy, I really thought I had it going on. I really thought I was the smartest person in the room in any room that I was in, as young people tend to do. But I remember thinking, man, this guy is brilliant. He's really, really smart. And then I remember another juror who was juror number 1. I was juror number 2. I sat next to her in the jury box for the entire trial. She took the most notes of anybody. And when we got into the jury deliberation room, it was like she was attending a different trial. She was writing down things that didn't happen, like weren't said, weren't testified to. It was crazy. Robin says, I think it would be very interesting if you could get a court clerk to come on and share what should have happened. Yeah, except it would probably be, there would probably be an ethical boundary that would keep most of them from doing that. But it would be cool. Would be cool indeed. Let's see if there's anything else. Okay, great comments, guys. Great comments. Let's see. Information Junkie says, you were discussing cutting your hair a few episodes back. I vote to not cut your hair super short again. I know you've been waiting on my analysis, so there you go. Guys, I am so ready to cut this hair, and it's borderline right now. Like I can cut it and donate it if I cut it short. And I am like so past having long hair. So thank you. I was waiting for that analysis information, Jucky, and I would love to hear the analyses of other viewers if you guys want to put it in there. Put GF in the comments so that I don't miss it. Don't accidentally miss it. Okay, let's continue coming back over here. Push the right button. Javi, is that the right button? Thank you, Javi. Okay. Rhonda McElveen, the Barnwell County Clerk of Court who assisted Hill with the trial, testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. McElveen testified that after hearing Hill had given a juror a ride home, what? McElveen counseled her that it was inappropriate, and while Hill admitted she gave the juror a ride, she claimed the bailiff was with them and they did not discuss the case. Although McElveen did not hear Hill say anything appropriate to the jurors, she stated that Hill made comments to her, staff, and media members strikingly similar to those juror Z reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements while he testified. Finally, McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. Oh my goodness. Wow. I was not paying attention to any of this when it was happening. As far as like Hill's prosecution. Okay, next, Murdaugh called the alternate juror to testify. She described the incident in which Hill made her comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the two jury rooms or were standing in the hall, Hill stood at the doorway and told them, "They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off." The alternate juror also testified that Hill told the jurors not to be nervous and don't be afraid to show your emotions because that's what they want to see. The alternate juror related she heard a court staff member say deliberations should not take long, but she could not remember who said it. In its order, the post-trial court declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. It then found Hill made improper comments to the jurors on the day Murdaugh testified, e.g., "This is an important day" or "This is an epic day," and that they should watch Murdaugh's body language. The post-trial court determined Hill's denial of making these statements was not credible, finding Hill wanted to write a book which she believed a guilty verdict would help sell. She was attracted by the siren call of celebrity, and she allowed her desire for public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Next, the post-trial court found that these comments did not affect the juror's verdict. It explained Juror G's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing Juror Z had acknowledged her statement in her affidavit that she had voted guilty due to pressure from other jurors. That was the more accurate statement. The post-trial court further found that Hill's comments, quote, "were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence," close quote, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh had failed to meet his burden to prove prejudice, any presumption of prejudice was overcome. It therefore denied Murdaugh's motion for a new trial. Murdaugh timely appealed to the Court of Appeals. This court certified the appeal of the denial of the motion for new trial and subsequently consolidated it with direct appeal. Okay, and then it goes through law and analysis. I don't know that we need to go through all of the law and analysis. Because this is all going to be case law. Let's skip the 78 million pages of this and get to the next part. It goes through rules, and if I were an attorney, maybe I would analyze this a little bit, but I'm not. Okay, now, so they go through all the case law. For those of you listening, not watching, I yada about 12 pages of that. Okay. Now we get to evidence of Murdaugh's financial crimes. Okay. Because we order a new trial on the basis of Hill's improper influence on the jury on appeal from the court denying Murdaugh's motion for a new trial, it is not necessary that we address the evidentiary issues Murdaugh raises on appeal from his convictions and sentences. We elect, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. Okay. At the time of the trial, Murdaugh had been accused of and indicted for numerous financial crimes. During his testimony before the jury, Murdaugh admitted he committed the financial crimes, although he had not at the time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to concurrent 27 years in state prison and 40 years in federal prison. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purposes of showing his motive for committing the murders. The state filed a pretrial motion in which it argued the evidence demonstrated, quote, Murdaugh accrued substantial debts over a period of years, and to cover those debts, began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own firm. Close quote. The state emphasized that several series of events unfolded in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, quote, all of these factors start to converge on June 7, 2021, the date of the murders. That's the end of quote. The state explained its motive theory. The murders served the Murdaugh's means to shift the focus away from himself and buy himself some additional time to try and prevent his financial crimes from being uncovered. The state also stressed Murdaugh's attempts to cover his financial misdeeds after the murders to support its theory of motive. Murdaugh filed a memorandum arguing the financial crimes evidence should be excluded under these rules, 402, 403, 404B. The trial court conducted a lengthy pretrial hearing but declined to rule on the admissibility of the financial crimes evidence at the time. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses regarding Murdaugh's financial crimes outside the presence of the jury. After hearing this testimony and the arguments of both sides, the trial court found all evidence of financial crimes that may likely have led to the motive or lend itself to motive for the crime committed was admissible. The trial court stated the jury was entitled to consider whether the apparent desperation of Mr. Murdaugh because of his dire financial situation, threat of being exposed for committing the crimes for which he was later charged with. Listen, you don't need to put a with after you've already done a for which he was later charged. You could just edit out the with, okay? And we can thank, I can thank Mrs. Curtis in 9th grade for teaching me that one. Anyway, where are we? Resulted in the commission of the alleged crimes. The trial court also found this evidence of other crimes is admissible and its non-propensity, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground than the specific charge. The trial court found the evidence had sufficient probative value that was not substantially outweighed by any danger of unfair prejudice. The trial court issued a written order setting forth its ruling. The state then presented testimony to the jury from the 8 witnesses who testified earlier, along with 2 additional witnesses. Through these witnesses, the state proved Murdaugh committed wide-ranging financial crimes over numerous years in several general categories, including the following. 1. Murdaugh stole money from his clients by billing personal expenses to them under the guise of those expenses being costs associated with their cases. 2. Murdaugh stole money from his law firm, by instructing law firm employees to make checks payable to Palmetto State Bank, whose then chief executive officer, Russell Lafitte, enabled Murdaugh to convert the funds for his personal use. 3. Murdaugh stole money from his clients and his law firm by instructing law firm employees to make checks payable to Forge, a fake account Murdaugh created to imitate the legitimate Forge Consulting LLC firm that Murdaugh then deposited and used for personal expenses, and 4, Murdaugh stole money from Tony Satterfield by filing an insurance claim in relation to his mother, Gloria Satterfield's death, and collecting the insurance proceeds for personal use instead of providing the proceeds to Tony and Gloria's other son. What a winner. The state also presented evidence to the jury that Murdaugh's years of years of stealing money in these ways was about to be exposed. For example, law firm employees testified they asked Murdaugh on at least 2 occasions in the weeks leading up to the murders about discrepancies in his financial disbursement documents in individual cases. Jeannie Seckinger, the firm's chief financial officer, testified she confronted Murdaugh on the morning of the murders, stating, quote, "I have reason to believe that you received attorney's fees in a certain case directly to you, and you need to prove to me that you did not." Close quote. Other evidence indicated Seckinger was referring to $792,000 in missing attorney's fees the firm was supposed to receive from Murdaugh's co-counsel Chris Wilson. The state also presented evidence that Mark Tinsley, the attorney representing the family of a young woman who died in the boat wreck, that of course, wrong button, Gavin, was Mallory Beach, had scheduled a motion hearing for 3 days after the murders in which Tinsley sought to compel Murdaugh to disclose his detailed financial records. Murdaugh challenges the admissibility of evidence of his financial crimes under Rules 401, 402, 403, 404B. And then, what is it? We won't do the parentheticals. As to Murdaugh's relevance objection, the state argues that because Murdaugh was charged with murdering his wife and son, seemingly inexplicable conduct when standing alone, it was important that it offer evidence to explain why he did it. The state also argues Murdaugh himself placed the issue of motive front and center through his own actions by suggesting to officers who arrived at Moselle on June 7th that the killer's motive stemmed from the boat wreck. Now, here is the court saying, "We agree with the state that evidence of Murdaugh's financial crimes made the state's theory of motive more probable. Thus, we find the trial court acted within its discretion in finding the financial crimes evidence was relevant under Rule 401 and admissible under Rule 402. The more difficult question is whether the trial court should have excluded all or some of the financial crimes evidence pursuant to Rule 404B or Rule 403. We address this question as 2 distinct categories of issues. The first of these categories, whether the trial court should have excluded all the financial crimes evidence, is a point on which not all members of the court would have ruled the same way had we been the trial court. We each agree, however, this was a decision within the discretion of the trial court under the facts and circumstances that existed in the murder trial. What they just said there was like, okay, under 401 and 402, we all agree. The court acted properly. So we just have these other 2 things. Now, under 404B, under either 404B or 403, we all would have ruled differently were we the trial court. However, we all agree that what the trial court did was appropriate. So they're like, yeah. So anyway, as to the second category, we will address whether the trial court should have restricted the extent to which the state was allowed to present the evidence, that is, whether the trial court should have excluded some of the evidence. We unanimously hold the trial court allowed the state to go too far and, allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive, which gave rise to considerable danger of unfair prejudice and therefore should have been excluded. Interesting. As to whether the trial court should have excluded all evidence of Murdaugh's financial crimes under Rules 403 or 404B, we have discussed the principles applicable when a trial court is asked to exclude evidence of other crimes in numerous cases, and no further elaboration on those principles is necessary here. And then there's a whole bunch of case law. As to Rule 404B, the difficulty lies in the application of these principles to the facts and circumstances of any individual case. Here, the trial court correctly understood the applicable principles of law and thoughtfully applied those principles to the facts and circumstances before it. The trial court explained its view of the logical connection between the financial crimes and Murdaugh's motive. The state argument that it presented a valid theory of motive and Murdaugh's response that fabricated motive theory is illogical and plausible and not supported by the evidence was not a dispute for the trial court to resolve by making this evidentiary ruling. That was for the jury. The trial court's job was to determine in its discretion whether the state's theory of motive was reasonably plausible, and if so, whether the evidence the state presented could reasonably support the theory. We agree with the state that under the facts and circumstances in existence in Murdaugh's first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404B. As to Rule 403, the trial court balanced the probative value of the evidence against its potential for unfair prejudice and concluded the probative value was not substantially outweighed by any unfair prejudice. The trial court specifically found Murdaugh's commission of the financial crimes does not suggest that to the jury that the defendant has a tendency to commit murder. As we will discuss below, we find considerable unfair prejudice in allowing the state to go as far and deep into detail as it did. However, we hold the trial court acted within its discretion in admitting some evidence of his financial crimes. And then there's case law. We emphasize, however, the trial court should have limited the state's presentation of this evidence. We illustrate this point with an example from the direct examination of Tony Satterfield. State, why were you the personal representative and not your brother? Satterfield, because my brother is a vulnerable adult and he has a disability. Court, can you repeat those words for me? Satterfield, that my brother, he's a vulnerable adult and he's not able to function as a normal human being to deal with stuff like that. State, he's a vulnerable adult? Satterfield, yes. This particular testimony, continues the court, had zero probative value as to Murdaugh's motive for the murders, and obviously high potential for unfair prejudice as it portrays Murdaugh as a man who preys on vulnerable victims. Interesting. Huh. I'm sure that when Satterfield made that testimony, the state was like, can you repeat that? Please repeat that, right? Much of the additional details the state presented as to Murdaugh's financial crimes had little or no probative value for the purpose of establishing Murdaugh's motive. The state's theory of motive centers on the point that his financial crimes were about to be exposed and he needed time. The fact he committed some of those crimes against a vulnerable adult adds nothing to the theory. To the extent many similar details may have had minimal probative value, that value is substantially outweighed by the unfairly prejudicial sympathy the jury was likely to feel toward this victim. By our calculation, the state spent a total of 12 and a half hours of actual testimony before the jury over 10 days of trial to introduce evidence related to Murdaugh's financial crimes. We are convinced the state should have effectively presented evidence to support its motive theory in a fraction of that time. So this is a bit of a win. This is a bit of a win for Murdaugh. If he's getting a new trial, which he is, the court appears to me anyway to be limiting what the trial court should allow the state to do. They're saying that there was prejudicial testimony. Ooh. 12 and a half hours of it. Well, I don't know. Some of the 12 and a half hours was prejudicial testimony. Okay, by holding the trial court in this case acted within its discretion in admitting some evidence of Murdaugh's financial crimes, we certainly do not intend to require the evidence be admitted on retrial. So you don't have to do it. As is often the case, the facts and circumstances on retrial may be material different from those presented in the initial trial. Thus, the trial court trial court on remand must do as the trial court did here, carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, the state must complete its introduction of that evidence efficiently without the lengthy presentation of inflammatory details with little to no probative value that was permitted in the first trial. Interesting. Guys, ooh. Listen, you can never trust a jury. I'm not saying jurors are bad people. What I'm saying is you can never trust them to come back with what you think that they should come back with. I personally have watched 2 murder trials in the last 2.5, 3 years in Western Pennsylvania where I was just like, dude, because I was privy to all the other hearings, right? The jury got this wrong. The jury got it wrong. And in both cases, they convicted the guy. And in one of the cases, one of the jurors is an acquaintance, a friendly acquaintance of mine. And I just like, I won't talk to him about it because I'm like, dude, you just got it so wrong. Anyway, conclusion. Let's see. Before we get to the conclusion, let's see what you guys are saying over here. Clarinet Girl says, Gavin, as a South Carolinian, I watched every second of the trial. Stealing money from his longtime lawyer friends is despicable. It is. I agree. Robin says, but also you shouldn't put a with if you have a for two. Exactly. Poor English skills brought to you by not paying attention. Oh, that is funny. Yeah. And Mooney's like, there's no way this man spent millions on an addiction. Yeah, I don't know what he was spending it on. I don't know. Yeah. Great comments. Okay. Conclusion. As the Fourth Circuit declared, the Remmer presumption is alive and well. It serves to protect the right to a fair trial by an impartial jury for all defendants. Here, Hill, the Colleton County Clerk of Court, egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge, the superbly competent and professional counsel for the state and the defense. Another compliment to the court and both sides of this. We are accordingly constrained to reverse the post-trial court's denial of Murdaugh's motion and remand for a new trial consistent with this opinion. Reversed and remanded. Kittredge, C.J., Few, James Hill, and Verndon, J.J. concur. So Kittredge is the chief judge. I don't know what J.J. is. I guess they're associate judges or junior judges. I don't know what they call them there in South Carolina. But okay, so what do we learn? One, Ms. Hill acted as a piece of dookie. I was about to say that Hill is a piece of dookie. I don't know if I'd go that far. She certainly acted like one. And she pleaded guilty to her actions. And therefore, I am not going to use alleged. I like this picture where she's like, oh, I am under oath. I will not perjure myself. Later on, I plead guilty to perjury. She acted like a little piece of Duke, and she is now giving this murderer a new trial. And you know what that makes me? Guys, I don't pull this one out very often. It makes me P-I-S-T. That's what it makes me. It makes me P-I-S-T. I am oft of the pissiness. That's what I am. This woman right here, thinking long, carefully while she's in court. acted as a piece of dookie. And now, I mean, what's going to happen? Well, I mean, the state has been constrained more than they were before. The state has been constrained in the amount of evidence that they can put forward on the financial crimes. And the court basically said, you can only present evidence of financial crimes that go to motive, not go to character. You may not prejudice the jury. And so if we don't have this lady outside the courtroom prejudicing the jury, and we don't have the state inside the courtroom prejudicing the jury because of presentation of his financial crimes, will the next jury be a little more sympathetic to this guy? I don't know. I hope not, because I think he murdered his wife and son, which is just a new level of evil. It's a different level of evil. Like on the murder spectrum, it's to me, murdering your own wife and child is beyond. It's like from, I don't know, from manslaughter to Jeffrey Dahmer. It's past Jeffrey Dahmer, right? It's beyond cannibalism. It's beyond serial. That is just my opinion. It's just terrible. It's terrible. It's terrible. So I fear a little bit that there will be an idiot juror that will, cause a mistrial. Or, I mean, just as bad would be, or even worse would be somebody who is sincere and is able to convince the other jurors that he is not guilty. And that's a frightening thought. Let's see what you guys are saying over here. Robin is asking, how much do I pay my little sister for the PIST residuals? I pay her nothing. Except I really, really love her. I did buy her a frozen yogurt while I was in town a couple weeks ago. I did do that. Yeah. All right, that is our report today, guys, on the situation with Alex Murdaugh. I mean, the good news is we will be, and the bad news is we'll be talking about Alex Murdaugh now for the foreseeable future. Dang it! But I mean, that's what we do here, right? But we're not done. Don't despair, my friends. Do not despair. We have more stuff to do before we call it a night. What should we do first? I think we stay in order. Let's head on into 3 questions.
It's 3 questions with Gavin Fish.
Okie dokie, guys. In this segment, as you know, unless you're new here, and if you are new here, thank you so much for being here. And if you're new here, this is the first giveaway we've ever done. The first giveaway we have ever done, we're giving away this Omega Speedmaster. All you have to do is go to fanofthem.com/GavinFish. Buy some merch over there and you're automatically entered into the giveaway. I'm a person who loves watches. I love chunky, traditionally male watches on a woman's wrist. I think it just looks awesome. And a Speedmaster is one of my dream watches. So definitely go to fanofthem.com/GavinFish. Enter the contest by buying some merch or digital downloads over there. And thank you, Fan of Them, for doing that with us. I am really, really excited for this giveaway. I'm just really excited. Okay, Question number 1. In this segment, I answer 3 questions that are sent to 3questions at gavinfish.com, 3questions at gavinfish.com, spelled out THREE questions at gavinfish.com. I solemnly promise that I will answer all of y'all's questions, and I will do so completely to the best of my knowledge. I particularly like the kinds of questions that y'all can answer in the live comments and in the comments afterwards for the rewatch crew on Spotify and on YouTube and on Facebook and wherever you get your podcasts. But you can ask me anything. The only catch is I get to answer the questions in the order that I deem that I want to order them in. So this one from Kelly: will you be following the Sandra Birchmore case? Yes. I am drawn to cases of corruption and acrimony. I especially abhor police corruption. Police corruption on like an office level or on an individual level, I hate it. And poor Sandra Birchmore was abused and murdered, and we will be following the case. Yes. Thank you, Kelly. I will put a button on my Stream Deck here so that I don't forget. Thank you so much for that. CM Warren 58 says, in a court of law, would you rather be a defender or a prosecutor? I feel no. I don't feel more drawn to either side. I think that both sides are important. I think that attorneys that go into criminal law should be both. They should start somewhere and try the other side. Like Josh Ritter, right? He's a prosecutor in Los Angeles County for years, and now he's a criminal defense attorney, and I think that's terrific. So I'm not drawn to either one, but you know what I am drawn to? A better living. And if you're a good defense attorney, make a good living. So that's probably where I would go. And I would be okay defending the O.J. Simpson of the world, the believe it or not, the Stephens Stern, the Davids Burke. I would be fine defending them because I deeply believe that our judicial system is the best in the world. Certainly flawed, but it's the best in the world, and that defendants deserve a vigorous and competent defense. Having said all that, I am not a lawyer. Question number 3. What's one hobby you've always wanted to try? This from Kim. Guys, here's the thing about me, and you may have picked up on this. If I have an interest in something, I do it. I try it. There is nothing that I have always wanted to do that I have not done. And it's something that is a bit, I mean, you can definitely, what's the word I'm looking for? You could criticize me for that. I mean, there's a family in Northern California that made a whole video on me, and they talked about how, he claims he's this, he claims he's that, and he claims he's done this, but nobody does all those things. Well, I am a person that is a curious person. And so, yeah, I have done all the things that I say I've done. I don't claim that I'm good or particularly accomplished at any one of them. What is a hobby that I've always wanted to try? I've tried all of them that I wanted to try. And if something comes up and it's something new or it tickles my fancy for the first time, and I say, man, I want to try that. You know what I'm going to do? I'm going to try it. It's what I do. And poor Kimberly, my sweetie pie, my snuggly bear, my one and only, she just has to deal with, I'm like Doug on Up, right? It's like, squirrel. I'm that guy. Something comes up and I'm like, I mean, I just started painting like in the last 5 or 6 months. I had never painted before in my life, and I'm not particularly good at it, but I'm doing it and I'm having fun, and it's bringing me some self therapy. So yeah, and yeah, it probably drove her nuts that I spent a couple $100 on paints and on actually it didn't because she came home with some canvases for me. She she knew that it was good for my mental health. But anyway, yeah, my poor wife. And like right now, like let me tell you one thing that I'm really into right now, and it's family history. I have thousands of negatives that I'm digitizing right now, and I'm having such a good time doing it. And it's not only family history. I mean, those negatives are all from my parents, but and my grandparents. But I'm doing it for I'm like digitizing things for uh, you know kids that I went to school with, elementary school and middle school and high school. I'm just enjoying uh, creating and documenting a personal history and a history of my friends. And so there's always something that I'm going to be trying that's new, things that I'm returning to. Like right now, we're building out. I've got everything now. We're actually we're ve- on Saturday. My son and I are going to be developing film, black and white film. That was my hobby when I was a teenager. It was my passion when I was a teenager. I haven't done it in 35 years, but well, it's 33 years or something like that, right? I think I was 17 the last time I developed a roll of film. And on Saturday, that's what we're doing. We're developing a roll of film. And um, it's just it's just fun. And I bought you see the camera behind me, that little Mamiya RZ67. That was my dream camera when I was a kid. There was no way that I could afford it, and I bought it uh, last year. And now I'm getting everything ready so that I can do everything from taking the medium format photos all the way through printing them. And I just that's what I do. And then, you know, in a few months, the dark room will go dark, for a while, and I'll move on to something else. It's just kind of it's who I am. I'd love to hear what you guys do. So, what are your answers to these three questions? Right? What's a hobby that you've always wanted to try, or are you more like me? Would you rather be a defense attorney or a prosecutor? And do you think I should be following the Sandra Birchmore case? And what are other cases that you think I should be following? And while you are telling me that in the chat, let's catch up in our final segment on some headlines that are happening in the world of true crime. Here we go.
True crime headlines.
Guys, I don't know why I'm doing this to myself. I don't know why I am doing this to myself, but there is a Kourtney Kardashian angle on the Nancy Guthrie case. Why am I even bringing this up? You know why? You know why? It's because I think that the case needs to continue to have eyeballs on it. So, not Kourtney. I don't even, Chloe. I don't even know which one that is. I just, I, but she said something about the case that made a whole bunch of people report on it in a bunch of publications, and that is a good thing. So here we are, USA Today, written by Saman Shafiq. Khloe Kardashian thinks there is more to Nancy Guthrie's disappearance. Well, I am all ears to Khloe Kardashian. Khloe Kardashian does not understand why Nancy Guthrie is still missing. Quote, Nancy Guthrie, I mean, is that not heartbreaking? The Kardashian sister said on her podcast, Chloe in Wonderland, uploaded May 13th. This is 2026. There is nothing. Kardashian, a self-confessed true crime junkie. Okay, well, I shouldn't come down on her. That's who we all are. Was in conversation with weekly true crime podcast crime junkie host Ashley Flowers, who, according to the episode's description, has helped solve over 20 cold cases. Wow. Let's see. Kardashian said while she's not sure if she knows enough about the case, things like the brother-in-law, the ransom notes to media outlets, and that kind of stuff were weird. Okay. Yeah, we all know. Okay. Anyway, let's just remember Nancy Guthrie. It's still not solved, okay? I'm happy that Khloe Kardashian has brought maybe a little bit of adrenaline to the case. I just can't continue to read it. I just can't. Okay, next headline. In the Anna Kepner case, not surprisingly, we've had a postponement of the jury trial. This reported by Fox 35 in Orlando, written by Camille Sarabia. Anna Kepner update. September jury trial date for stepbrother accused of killing teen girl. Dateline, Titusville, Florida. A trial date for a Florida teen accused of killing his stepsister while on family vacation has been moved to September. Timothy Hudson, 16, who is accused of killing Titusville cheerleader Anna Kepner in November 2025 while on a Carnival cruise trip, will have a criminal jury trial in 4 months on September 8th. Hudson's initial trial date was June 1st. This new trial date comes after Hudson pleaded not guilty on April 22nd and requested a jury trial. Of course, we all need to keep in mind that they have to put the date on the calendar. Will this date stick? I doubt it. Less than a year between the time the crime happened and the trial, not likely. Not likely. He's already waived his right to a free trial. I don't think there's anything else. Yeah. Okay. So he'll be back in court on May 22nd. That's basically what we need to know here. Hey, in the Judge Kevin Mullins murder, we've got a little bit of movement written by Anthony Sizemore for WYMT. Court appearance ordered for former sheriff charged with murder. Dateline, Letcher County, Kentucky. Former Letcher County Sheriff Sean Mickey Steins has been ordered to appear in court next month. New court documents say a status hearing, as well as a hearing on all pending motions, was scheduled for 10 a.m. on June 5th inside the Leslie County District Courtroom. The court is expected to hear arguments from the parties on all pending pretrial motions. Of course, that was all kind of postponed while the defense was trying to get the judge kicked from the case. I did get this document from the court. It basically just says what the report says, so I can upload it to Patreon if you guys want that document, which I will gladly do that. I will do that tonight. And then finally, for headlines, before we get into good news, this from Fox 56. Do you guys remember the case of Laken Snelling? Written by Corey Elam. Laken Snelling, former University of Kentucky student indicted in baby's death due in Fayette County Circuit Court ahead of status hearing. Dateline, Lexington. A former University of Kentucky student indicted in March in connection with the death of her baby in 2025 is due in court on Thursday for a pretrial hearing. That would have happened today. I wonder if are any reports of what happened. Let me see if there's any new reports here. There aren't any new reports, so we'll continue with this one. Snelling, 22, is indicted on March 10th and entered a not guilty plea to charges of first-degree manslaughter, abuse of corpse, tampering with physical evidence, and concealing the birth of an infant. At 10:30 a.m. on Thursday, May 14th, Snelling is due in court for a pretrial conference ahead of a status hearing scheduled for June 12th. So not much is going to happen there. It's just that we know that something is happening, and that is a good thing. Now, I want to get to some good news, but Wanda, how about some transition music? What do you? Oh, they're all here. Yes, please. Let's have your nephews and your grandchildren transition us to happy good news. Let's hear it.
Let's transition now. Yes, transition now.
Ooh, I liked the clicks, fellas. Do you have anything else that you could do?
Let's transition.
Yeah.
Yes, transition now. Yes, transition now. Yes, transition now. Let's transition now. Yes, transition.
Oh, it's still going. Well done, guys. That was a good transition to some good news from the Good News Network, written by Andy Corbley. A study shows litter declined 34% across America since 2020. And that makes me happy. And it certainly makes the man in the 1970s commercials who was imitating a Native American was not a Native American and had a tear going down his it has to make him happy, okay? Andy writes, litter across America has declined 34% since 2020, according to a new report from the charity Keep America Beautiful. The report reckons that every American's share of litter along roadways and waterways has fallen over that time from 152 pieces to 96. Guys, my share of litter across the highways is 0. If something accidentally blows out of a window and I'm going 95 miles an hour, which I wouldn't do because I am an obeyer of traffic laws, I would turn around, go back, and find that piece of, like, I was taught well by my parents. But I see how averages work. I am responsible for 96 apparently. Decades ago, GNN founder Jerry Weiss Corbley organized a local spring cleanup along her neighborhood's country roads every year when she was raising kids. Quote, I can tell looking at the roads now that littering is way down because I live in the same neighborhood and there aren't any organized cleanups anymore. Close quote. The study, which updates the groundbreaking Keep America Beautiful, take two, Javi, Keep America Beautiful 2020 National Litter Study, is the most extensive research conducted in U.S. history to estimate the scope, scale, causes, and impacts of litter. KAB states that it provides both a progress report and a roadmap for where urgent action on litter is still needed as the country approaches its 250th birthday in less than 2 months. By the numbers, roadway litter declined 22%, 23.7 billion to 18.4 billion pieces, while waterway litter fell 45% from 25.9 billion to 14.2 billion pieces. By the way, I encourage everybody to follow Ocean Cleanup. Go on YouTube, search them. They're doing amazing work. They're focusing. They want to clean our oceans, and they're focusing on the rivers where all the waste comes from. It's brilliant. Ocean Cleanup. Go check them out. The declines are being driven by a combination of factors: education that shapes behavior, strong local programs and enforcement, better infrastructure, and access to waste systems, and increased public engagement from businesses, organizations, governments, and individuals. Quote, this study proves what we've always believed: litter is solvable when people, systems, and partners work together, said Jennifer Lawson, president and CEO of Keep America Beautiful. Quote, the declines show us what's possible when communities act with urgency and commitment, but our work is far from done. With 35 billion pieces of litter still out there and new types emerging, we must scale what's working, close the remaining gaps in infrastructure, and access, and continue building on this momentum. Nearly 90% of Americans feel personal responsibility to reduce litter, and 93% agree it's a shared community responsibility among those polled for the study. So, guys, yeah, you can keep reading the rest of it. It is linked in the description and show notes. But that is, I don't know, that's happy news. That is happy news. I am grateful that litter is on the decline. So awesome. Before we go, let's just see what your answers are to 3 questions. What do we got? Let's see. Seashore CJ says, nice job of covering Murdaugh mess. Thank you. Mooney says, I want to skydive. Forgot to put a GF in my comment. Yeah, I would have missed that. Skydiving isn't anything that I ever really cared to do, but my oldest sister and brother-in-law and like a few of their kids went skydiving pretty recently for the first time, and that's pretty cool. I just don't want to jump out of a perfectly good airplane. I like the flying part of it. The falling part of it, not so much. Elizabeth says, I would prefer being a prosecutor, especially today. I'm an elder law and estate planning attorney, and I need a break. Bring on the criminals. Nice. Archangel Marici. Okay, first TMZ and now the Kardashians. I know. I deserve that comment. And Elizabeth says, well, thank you, Chloe. Clarinet Girl, are you following Lynette Hooker case out of the Bahamas? This is one that Joel is following, right? I need to. Definitely need to do that. Thank you very much. Just Ducky says, my friends got me into their hobby of ham radio after they connected with the International Space Station. True story. I was hooked. That's cool. Ham radio is cool. I like ham radio. I mean, that's nothing that I've ever done, but I did do the ham radio merit badge as a kiddo. So I was exposed to it, right? And it was fun. Clarinet Girl continues. Ashley Banfield has lots of comments on the Lynette Hooker, or lots of videos on the Lynette Hooker case. I would check that out. Thank you. Marie Jubenville says, I would love to write a children's book about children with disabilities and the overall message that they are not alone and never give up. That would be terrific. You should do that. Archangel Marici says, sorry to say, but Wanda's son is too low. He's a little flat. Is that what you're saying? A little flat, or is he right on pitch, but it hurts your ear? Guys, can we hear that one more time? Let's hear it.
Let's transition now. Yes, transition now. Yes, transition now. Yes,
Transition now. No, I think he's right on. But you know what? Who knows? Thank you very much for that one. Guys, I appreciate your comments. You guys are amazing. Thank you for joining me. I am so sorry that I missed yesterday dealing with gremlins with, the volume was too low. I have the volume turned down. You're right. Okay, one more time, guys. Here we go.
Let's transition now. Yes, transition now. Yes, transition now. Yes, transition now. Let's transition now. Yes, transition now.
Oh, that's much better. Okay. Man, I had that turned down. Dang it. I'm sorry you couldn't hear that. The transition music was not good today. I blame myself. You guys might want to blame Javier Marcelo Guillermo Juanjo Ruben Navarro Torres de los Andes, but it wasn't him. It was me, and I will repent. I have repented. I have made it right, and will try. And you know what, Wanda? I think what we need to do is we need to come up with some good news specific music. Just some music to go into good news. You think you can do that? Like, I think we should. It's become a thing. We're sticking with it. It's become a segment. We should have a stinger for it. Yeah, I agree. Okay, we're going to do that. Guys, thank you so much for being here. Do not forget about the giveaway. It supports the channel, it supports my work, and it gives you a chance to win this amazing Speedmaster, a watch that I covet and love and hope that you guys love too. Please head over to fanofthem.com/Gavin Fish. The deadline is May 21st. That's like less than a week away now at 11:59 p.m. Pacific time. And then we won't. A third party is going to find a winner, is going to like draw a winner. I'm pretty stoked about that. So fanofthem.com/Gavin Fish. You can always visit me on the old website, gavinfish.com. Let's bring that up there. gavinfish.com. It looks like this. We've got Crime Cod fixed again. Jake and Kate were working hard and getting us a couple stories a day. We now have a couple of other authors up there that are filling us out. Also, hey, on Crime Cod, if you go to Crime Cod for the first time, it'll open up looking like this, and there will be a little pop-up window, I think. Usually there is, maybe not. But if you scroll down, oh, there it is. You can subscribe to the old newsletter. You can join about 3,000 other people to subscribe to that newsletter. Gee, I wish you would. And I try to send that out on Tuesdays, though my system was broken. I've had gremlins, man. So it went out today, but it'll come out on Tuesday again. And then don't forget to join us on Facebook if that is your thing, in the fish tank. Me and about 6,300 of my closest friends, we hang out and we talk about true crime. With that, guys, I bid you adieu. Thank you very much for being here. See you tomorrow, same time, right here at the same place. And until then, please take care of yourselves. Bye-bye. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.